Hi, I'm Paul Golden. I will give an outline of what people can do when they want to make a complaint for violence in childbirth, particularly some call it obstetric violence, I call it violence. If the same thing happened outside a hospital, it would not have the same protections that institutions appear to give to any kind of violence, whether it's educational, legal, or healthcare institutions. There seems to be a reluctance for people to challenge. When the same thing could happen in a public place, they would definitely call the police. So let's look at it generally. You've got civil and criminal. On the civil side, well, let's actually look at the criminal first. It is an assault, a battery, a trespass to the person, and sexual violation. To have, for example, a vaginal examination without consent, and particularly when somebody's saying no, stop, and the person continues to do it, it's very clear. What's really helpful is evidence. Video evidence is the best thing. Everybody's a witness. Get witness statements. If there's no other witnesses, no video, no audio, at least your own evidence as the woman who this may have happened to. You want to write down all the facts. That means the who, how, why, what, where, and when. So you write down the date, the time, the place, what happened, without too much emotion. Focus on the facts of, if you know the name of the perpetrator or the person who did this. And I am generally aware there's a whole psychological thing which we will address as well, briefly, that the perpetrators are themselves often victims. However, they're repeating something. Why do they do it? They do it because they can. So many maternity units, people think they're being very kind, they may be smiling, may have a gentle attitude, and yet they're doing something that somebody said, no, stop, I don't want that. So that's breaking the law. Because it's in a hospital, the police don't generally investigate, but nobody complains generally. So if you would like to raise a complaint, now instead of a complaint, let's say raise a challenge or an issue, if we want to focus on it being positive. So tell the organisation, but you go outside the organisation to the police with a statement saying this happened. Imagine the same thing had happened outside of a hospital. You would be reporting it to the police. The police may not investigate, so you write to the chief constable for that area, and this is the same whether it's in India, in America, in Europe, in the UK, in Mexico, South America, anywhere, Russia, China. Every country has very similar laws, particularly criminal laws. So you've got your complaint, it's a statement, you've given it to the body that's responsible perhaps for the employment of the person, they've done nothing. You then look at the registration body for the person, you can consider going to them. I suggest go straight to court as far as possible, fill in the court application forms, get the ball rolling, because the threat of litigation is what gets mediation. Many complaints have gone on for years, even decades, and the person is frustrated and always believing that the next step of the complaint might bring a resolution or might help. No, go to court, they have to come to you and give answers as to what they did, why they did it, who did it, when they do this, what they've learnt from it, will they do it in future. And one person can make a big difference, and you will find you are not alone. I will look to make a flow diagram on all that I will say and maybe show some forms. One generally cannot take a criminal prosecution. One can take a private criminal prosecution, which is tricky and complicated, and at some point the Crown or the state can and will take over, or even take over and then drop the case. So you don't have full control over criminal prosecutions generally. It's the state that does. However, you can start one. When the police then fail to investigate, as they often do, you start a civil prosecution against the police. Prosecution is perhaps the wrong word, but you start a civil case against the police for three general things, which is wrongdoing in a public office, breach of statutory duty, the law requires them to do something and they haven't done it, protect the public, and three, negligence. They have done something or not done something, an omission, that has caused harm to you. That causation was reasonably foreseeable. Therefore, by the police failing to investigate, we know that you suffered harm and somebody else very likely is reasonably foreseeable will also suffer harm. And you find that when one woman complains about one hospital and the treatment there, another woman does. You're not doing it for that reason, hopefully. You're doing it for your own reasons, to stand up for your rights. And you only have the rights that you stand up for. So I hear people traumatise and they really need psychological help. But the next woman going in is going to get traumatised also. So what is it that's going to stop this cycle of abuse is people speaking out and taking action. So I emphasise the word action. Speaking out happens a lot. We can tell the negative narrative, the story about how bad something is or what happened to us, what the trauma was. We really need to focus on what we would like. When we focus on what we would like, we take action. The action can be words on paper, going to court, challenging a chief constable, saying you haven't investigated this, you would if it was outside a hospital, give your reasons, doesn't matter what they say, let's go to court. Let's get the judge to rule that the chief constable must investigate. And the threat of that, even before you get to court, very likely would get a chief constable saying, okay, let's investigate this. Why? Because they have to. So that human nature of people doing what they do because they can, and they won't if they can't. If they fear a judge is going to tell them off or give a judgment telling them to do something, that could cost them money. Even if they won their case, it would cost them money, but very likely they know they could lose. It's always unpredictable going to court. And it will cost them embarrassment as well as money. Saving face is very important for some, and that's where mediation is a useful offer. So you say, I'm happy to talk to you, but you haven't taken any action, therefore let's get clarity from the judge. Let's get a court decision that helps you to know that you have to investigate. So that's the criminal side. Get them to investigate the assault, the battery, the trespass to the person, the sexual violation. And in some cases, the mother or baby have died. That's gross negligent manslaughter very often, and nobody takes this case. Even the state will investigate, find that it's that, and then hide the case or bury it. I mean, the UK's had several reports, Mid Staffordshire, Cwm Taff, Wales, Nottingham, East Kent and others, and these are only the places that were reported on, that found avoidable, preventable deaths, and yet nobody even made a report available to the Crown Prosecution, to the Attorney General, to the Ministry of Justice. I mention the Ministry of Justice because if a Chief Constable fails, it's very good to write to the Ministry of Justice. They're covering all Chief Constables and saying, we are taking this action, or I am taking this action. But who wants to take an action when they've had a baby and they've had a traumatic time? If we don't take action, how will the next generation give birth? So I've witnessed trauma for over 30 years of being a midwife and a legal advisor, and I see the traumas repeated again and again. And in fact, it seems to be getting worse with lack of staff. With staff and resource shortages, people are pressed for time, they're under all sorts of other pressures. Now we've got COVID as a pressure on staff, and some of them are fantastically kind and always get consent and will give information so you get informed consent or refusal, and others seem to be missing something and they just dive in, think they're helping, and they're actually hurting. So their intention may be to help, but if they're causing harm, it needs to stop. The only way it stops is you taking action. The civil actions are, again, negligence. If there's harm, you have to show causation, that somebody did something that caused it to you. So if the PTSD, post-traumatic stress disorder, if the bleeding from the vagina, if the infection from the vagina, if the traumatic birth because of the clinical care caused you harm, that causation just has to be demonstrated. Again, courts are unpredictable. The fact you're taking a case saying that they caused it, and they might say, oh, you cannot prove that we caused it. Well, do they want to go to court and stand up and say that, or do they want to enter into some kind of useful conversation with you, apologise, fix things, send people on training, supervision, and review and listen to the consumer? Really review how they're listening, because we can all listen more. I'm certainly learning constantly to listen more. So the civil cases can be, again, wrongdoing in a public office for the chief executive of the hospital. presuming it's a hospital. And the same things, so wrongdoing, breach of statutory duty, negligence, causing harm. It's very easy for a court if you can show them that the harm was financial. But if it's emotional and psychological, you can say, well, I'm seeing the psychologist once a week for £50, euros, dollars for 10 weeks, 100 weeks, times that by 5 years treatment. There's a number, there's something quantifiable, and it's easier for a court to award damages. So you do have to go for numbers, you do have to go for money, even if that's not what you want. It's the way to get the apology is to go for the money, often. That's a very brief thing. In most countries there's a simple claim form, whether it's the basic county court, which has usually a ceiling limit of X amount, and if you want to go for higher amounts, it's the High Court, and that's usually costs more to file a claim. You don't have to have legal representation, you can do it yourself, and I recommend everybody do it themselves. They've got on and done a lot harder things in life than taking a case to the court, and be prepared to fail. So if you want to be certain you're not going to fail and you pay a lawyer, you could still fail and you've paid them as much as your house. So it's not worth paying a lawyer. If you can get one on your insurance or some other way of getting a free legal help or minimal cost one, possibly a no-win, no-fee one, I still think it's better to speak your truth. And the county court, for example, prefers people to be litigants in person. That is for you to turn up and speak your truth. The judge will listen and they will weigh and test the evidence and verify the evidence, and they will weigh the evidence to see which evidence is more credible, which is more believable and less believable. So that's my encouragement, is to fill in the claim form. If your country doesn't have or need a particular claim form, you simply put your details, their details, a brief summary of what the claim is, an even briefer one at the very beginning, a bit more detail, and then give a few pages, keeping it as short as you can. I would suggest you number all the paragraphs so that when somebody's referring to it, you can say paragraph 21, paragraph 36, and they know exactly where to go to. Make it easy for the fact finder to follow your argument. If you're getting emotional, stop. Make it short. Go to the next point. Emotional things are for the psychology, are for counselling, are for having tea with friends, to be upset and share. For court, it needs to be focused on facts. That's my emphasis, focus on facts. So edit yourself again, get somebody else to read it. Does it make sense? And you don't need them to be polite and friendly. You need them to be helpful and show you how it can be better, whatever statement you've written. If you can get statements from others, that's helpful, especially if you can get an expert witness statement. That could be from a nurse, a midwife, a doctor, for example, saying what was the reasonable standard of care and did that appear to have been given or not given in this case. And that can have a great benefit to your case. Some people will work for free, for low amounts of money, and some work for quite high amounts of money as a legal expert witness. They have a lot of responsibility because they can and will be cross-examined and may have to turn up to court to present their argument. And the judge can ask some questions as well as the other side, who will very likely have their own expert witness. In theory, an expert witness is working for the court. They're unbiased, they're not on anyone's side, but in reality, whoever pays them tends to influence them, and the report shows that. Okay, so if I wrote an expert witness report for somebody, it's more likely, let's not say it's biased, but that it would be in favour of the person who's paying me to write it. The same on the other side, and therefore the court is weighing up and looking at the two reports. Sometimes the court will say, go away together and find the areas you agree on, and then bring the report back with just that, the areas you agree on. Okay, it's quite quick to move through a complex subject. I do welcome questions. I will write things up more, and I hope to put with this video some links to court claim forms. Very basically, just do it. You live with the regret a lot longer than you do with if you make a mistake, if you get it wrong. It's always better to do something than to do nothing when it comes to challenging, particularly with legal issues. and the legal process can be slow. So the sooner you do this, you have 3 years for civil cases to claim any damages. Criminal law has no time limits on it. So you can say 10 years ago I was XYZ. I felt that my care was similar to being raped in labour, which is a common complaint from many women. Partners observed their, particularly like husbands or male partners or whatever partners, we observe the woman that we're with to suffer trauma and unnecessary trauma and abuse, and they themselves are secondary victims, including of post-traumatic stress disorder. And there have been successful cases for others, so long as they are proximal, very close to the incident or the person. They need to have a strong link with the person. So for example, at a big disaster, the football stadium in the UK, Hillsborough, many people claimed secondary victim to that, and that was successful. Weirdly, the police who had actually caused the problem by locking some gates and not letting people out that way, that was senior police. The other police who were there helping people were traumatised by witnessing the deaths and serious injuries. They claimed against their employer. So everybody claimed against the police. In that case, they were clearly very wrong. Things had happened. And quite often, every day in every hospital, there's usually very clear wrong things happening. However good and kind people are, we're getting it wrong in hospitals most days, most of the time. And the reports show that. And the reports are showing preventable deaths and serious injuries to mothers and babies, also to some staff. So clinicians are actually helped when we challenge them and say, I felt this, that and the other, and they perhaps never had a complaint, or it was just brushed under the carpet. Get it on a claim form or get it into writing as a witness statement, and ideally get it into court, even as a draft and not filing it. Send it to the chief exec on a court form. You will get a lot better responses from that. Okay, I do appreciate this is a very fast talk through. Obviously you can go back, listen to bits and pause bits, and people can ask questions to me. midwifemediator.com, midwifemediator@gmail.com. Wishing you great self-compassion. I did mention the psychology. That's a separate subject that I will do a video on.